The way these two are reconciled, my lord, is if in a setting aside application, and acting only within the narrow confines of a setting aside application, therefore not reviewing the merits of the matter, the conclusion axiomatically follows as to what will happen in the remanded arbitration, then to that limited extent, the court can modify the award. So, my lord, for example, in interest, if the arbitral tribunal has awarded interest contrary to the terms of the contract, and that is the reason the award on interest is being set aside, then the court can modify the interest rate. Because in a remanded arbitration or in a fresh arbitration, the only conclusion that will follow is the interest rate as per the contract. So, my lord, the way I try to articulate that in paragraphs 9 and 10 of my submissions, my lord, if your lordship will have it. Modification under section 34 is permissible only in situations where the court does not supplant the role of the arbitrator. Thus, for example, the exercise of modification cannot entail a review of the merits of the dispute. The court must find grounds to set aside the award or part thereof, and if the conclusion axiomatically flows from its findings, the court may modify the award to reach that axiomatic outcome. In that sense, the modification of the award is only a species of setting aside. And I've tried to give, my lord, two illustrations. Illustratively, if the tribunal awards interest contrary to the express terms of the contract, rather than relegating the parties to another arbitration, the court can grant interest according to the terms of the contract. Or B, if the tribunal finds breach of contract, but awards damages even though the contract stipulates liquidated damages, the court may modify the award and award liquidated damages in accordance with the contract. This then preserves for the parties that the decision is not being taken by a court when they have actually an arbitration agreement in place, saying that the arbitrators will finally decide the dispute between the parties. One last judgment, if I may place. This is, my lord, a Delhi High Court judgment, which puts the submission quite succinctly. That is, my lord, in my compilation. What page, Ankita? What page? Page 320, my lord.
Damages substitute is also not easy. They have to deal with extension letters.
No, my lord, if
that extent is what's rewriting the award.
No, my lord, if the facts of delay are clear, only to that extent, my lord. If the quantum of delay is already clear from the arbitral award and the court is not interfering with that, then you are doing a simple mathematics of, my lord, 0.5% per week for X number of weeks. Or, my lord, may I just take, not my example, my lord, a given example as my lord, the Chief Justice put it. If, my lord, the contract specifies a rate for the work to be done, and also specifies that if the work quantity exceeds a certain amount, a higher rate will be given. Let me just end with this one illustration and then I'll place the Delhi High Court decision.
Please, just continue.
Yes. If the contract prescribes, my lord, a particular rate for the first quantity of work and then a higher rate for the additional quantity, the tribunal awards the higher rate for the entire quantity. And the matter is not challenged, saying that the higher rate can only apply to the additional quantity. If the court is setting aside the award for taking what is not a plausible view of the contract, then the court can certainly, in my respectful submission, modify the award to give that additional rate only for the additional work, rather than set aside the award, rendering the parties back to an arbitration where the outcome is already known. That's one of the facts of my case. I was placing, my lord, this one.
Yes, please.
Yes, at paragraph 21, my lord.
Page number?
At page 325.
What's the name of the case?
My lord, this is Modern Laminators, footnote 8 of my submissions, my lord. 2008 SEC Online, Delhi, 956. Now, these guardrails have been well put, my lord, and that's why I'm placing this judgment.
Modern?
2000.
Oh, you told me
Page 320, my lord, of my compilation.
Yes.
Union of India versus Modern Laminators.
Filed by Miss Manisha Ambani.
No, my lord, by Mr. Nayak. I think my friend, my court master has pulled it out. No, the 10th,
Additional compilation.
Well, it's my compilation, additional compilation. Yes. Yes, Milord. Page 320.
Combined compilation of all the.
Milord, I
We should,
therefore,
in fact, sit down together at least 4-5 days.
that's why I didn't duplicate compilations, Milord, what had already been
And
filed by
look,
Mr.
look,
Datar.
all of you have spent so much money also, just,
We tried in this compilation not to duplicate what was already filed.
okay, yes, please.
Yes, Milord.
You've got a spare copy?
320, Milord, at 325. I'll just place these two paragraphs, Milord. Paragraph 21, Milord, at the bottom of page 325.
Yes, all right.
That's why I not have. No, Abbas. Jonathan, may I place it while you're not?
Yes.
In my opinion, the power given to the court to set aside the award,
Paragraph.
paragraph 21, at the bottom of page 325. Does my lord have it?
Yes.
In my opinion, the power given to the court to set aside the award necessarily includes a power to modify the award, notwithstanding absence of express power to modify the award as under the 1940 Act. Just as ONGC versus Saw Pipes interpreted the ground of award being against the public policy to include contrary to substantive provisions of law or against the terms of the contract. SVP interpreted the powers under 11.6 to be inclusive of judicial powers. The speedy disposal of lists is the underlying thought in the radical changes made in the arbitration law. If the powers of the court under Section 34 are restricted to not include power to modify, even where the court, without any elaborate inquiry and on the material already before the arbitrator, finds that the list should be finally settled with such modification, and if the courts are compelled to only set aside the award and to relegate the parties to second round of arbitration or to pursue other civil remedies, we would not be serving the purpose of expeditious or speedy disposal of lists and would be making arbitration as a form of alternate dispute resolution more cumbersome than the traditional judicial process. With great respect, I find myself unable to hold so. The Constitution Bench of Apex Court and SPP reversed the judgment of earlier Constitution Bench, inter alia holding that when a statute confers a power or imposes a duty on judicial authority, that authority, unless shown otherwise, has to act judicially. The Constitution Bench adopted the procedure laid therein in the context of the Act and to best serve the purpose sought to be achieved by the Act of expediting the process of arbitration without too many approaches to the court at various stages. And then, Milord, the guardrail also, para 22. Such modification of award would, however, have to be within the confines of interference with arbitral awards as held under the 1940 Act and would not permit the courts to substitute their opinion for that of the arbitrator. Such modification of award will be a species of setting aside only and would be setting aside to a limited extent. However, if the courts were to find that they cannot, within the confines of interference permissible or on the material before the arbitrator, are unable to modify, and if the same would include further fact-finding or adjudication of intricate questions of law, the parties ought to be left to the forum of their choice, that is to be relegated under 34(4) of the Act to further arbitration or other civil remedies. So, my respectful submission is that within the confines of the jurisdiction of Section 34, if the courts are able to find that there will only be one conclusion of this arbitration, even if the matter was to be fully set aside and a new arbitration would to ensue, that axiomatic conclusion, the courts can substitute. Milord, just my final paragraph, because the expert committee headed by Mr. Vishwanathan Milord, Vishwanathan Committee report, Milord, My Lord, the Chief Justice has para 12 of my submission.
Yes.
For this reason, it is respectfully submitted that the guardrail identified in the T.K. Vishwanathan Committee report that a court may modify the award only in exceptional circumstances to meet the ends of justice may not be precise or narrow enough to be workable. Similarly, instances where interest rates have been modified on the basis that the interest rate does not reflect the prevailing economic conditions or where it is not found reasonable or in the interest of justice may also be too broad a power to confer to a court under Section 120, Section 34 of the Act, without limiting the power of this court under Article 142. This is, my Lord, paragraph 11 of Vedanta that was placed in the morning. My submission is, my Lord, that within the 34 jurisdiction, within that exercise, and only if an outcome inevitably follows, then the court may modify that award. And, my Lord, your Lordship has been concerned, my Lord, with interest rates being awarded by tribunals, either too much in excess or not being given. My Lord, too much in excess, perhaps your Lordship's decision in Nepal Limited versus Manoj Agrawal, where now a party that deposits the money in court while challenging the award doesn't continue to suffer the
No,
interest
no.
rate awarded.
So that's your wrong reading of it. That's your wrong reading of it.
Your Lordships have said, my Lord, that
No, in Nepal, the money was paid back, paid to the party
yes,
concerned.
taken out from the court by the party.
That therefore I said the interest will stop running.
I'm grateful, my Lord. And your Lordships are routine, my Lord, the
No, no,
courts are
stop
routinely.
it. If you bear deposit, the interest rate doesn't stop.
Correct.
Really,
You are
Lordship,
disputing the liability. That's the thing. Ramanathan Chettiar.
No, what
In
I
Chettiar.
said, where the money has been paid to the party,
Yes, that's
withdrawn by the party, then it makes no difference, but where deposit of the money, you don't,
No, yes, I'm grateful, my Lord.
you don't save yourself from the interest.
Yes, your Lordships have said where it's deposited and withdrawn.
Maybe withdrawn also on furnishing security. In
Yes.
that case, it was made, it was not a bank guarantee and so forth.
Yes,
In bank guarantee cases, then we are asking them to pay even the bank guarantee.
a bank guarantee or some other security. That was my submission, my Lord, that today, my Lord, if a party is aggrieved by an award and the interest rate is very high,
What was being asked for was, the money was taken away and utilized whatnot. Now the award was upheld, so he said, no, now you pay me interest on that amount, even including the amount which I drawn.
I was only trying to say, my Lord, therefore, this issue of a very high interest rate has been largely addressed by your Lordship's decision, because when you suffer an award and you are challenging the award and the interest rate, you at least deposit the money in court, it is withdrawn by the other party on furnishing a security.
So the times the government it suffers on this account because they say don't allow withdrawal.
No,
They
then,
deposit the money, but
my Lord,
don't allow.
in that sense, my Lord, I and your Lordships, my Lord, have to deal with, my Lord, a variety of arbitrations, my Lord. But in a commercial arbitration, if a party refuses to comply with the award, then perhaps years later, it can only suffer the consequence of that high interest. I hope and that's why, my Lord, NEPA offers that opportunity to a party to say that if the award of interest is too high, you can stop the clock by depositing the money, and with an order of a court, the other side is permitted to withdraw the money. But if you don't deposit the money or resist a withdrawal of the money by the other side, then perhaps you don't need the discretionary relief of a court to later say the award of interest is too high. I'm very grateful, my Lord. Therefore, I would only end with this.
Yes, please.
My Lord, I would only end with this one last line. The Lakshman Rekha, according to me, is, my Lord, that courts will not substitute the decision-making of an arbitrator. Within that confine, and acting within Section 34, if there is a certain conclusion to the dispute, the courts are, my Lord, empowered under Section 34 to make that modification. I'm deeply obliged.
Sir, I am principally concerned with statutory arbitration.
You are appearing in which case?
In high number 100523
Okay.
and other
Statutory
connect
arbitration arising out of?
National Highways Act.
So for the private party or the?
Private party whose land is acquired. So my first submission is that there is a fundamental difference between statutory arbitration under the National Highways Act and arbitration under the Arbitration Act Arbitration under the National Highways Act involves public law elements. How to determine the compensation for the land which is acquired? All principles fall in the domain of public law. While commercial arbitration involves private law elements. This is one fundamental difference between the two. The second difference is that commercial arbitration is consensual. It's with the consent of the parties. While statutory arbitration is involuntary. I do not choose the arbitrator. Under section 3G, the arbitrator is appointed by the central government under the provisions of the National Highways Act. This court has noted in Hakim's case that there is inherent bias. Kindly see me note para 50, 55 and 59 of Hakim's case. It is there in Mr. Datta's compilation. Para 50, 55 and 59. And apart from this para, your lordships can take judicial notice of the fact that several cases have come to this court where the amount which is awarded under such arbitration is very small.
Very big.
That is why your lordships have interfered under Article 142. Even in this case, Hakim's case, your lordships have interfered, exercised power under 142, and your lordships have declined to interfere with the impugned award. So kindly see para 50. There is no doubt that, as argued by Mr. Balsubramaniam, the arbitral award in these cases is given by a government servant appointed by the central government, the result being the rubber stamping of compensation awarded or a completely perverse basis, given the facts that in these petitions at least, the constitutional validity of NH laws has not been challenged. We must proceed on the basis that a grave injustice would be done if we were to interfere on facts, set aside the award, and remand the matter to very government servant who took into account depressed land values which were relevant for the purposes of the stamp duty only. It may be mentioned at this juncture that a limited challenge was made to section 3J of the National Highways Act. Now this has been struck down. Then kindly come, my lord, to para 55.
Validity is pending, I think now, on 3G is pending.
3G is pending.
3J is struck down now. So therefore,
3G is pending.
no, 3G, this arbitration was under 3G.
It's pending, validity is pending.
So 3J is struck down. Therefore, all the principles which apply to acquisition under the Land Acquisition Act apply with equal force to this acquisition also. Now kindly see, my lord, para 52 on page 31 of the report. As has been stated by us, the object of the NH laws is to expedite the process of acquisition. This has been achieved by cutting down the period for hearing the objections from 30 days under section 5 of the Land Acquisition Act to 21 days under section 3C of the National Highways Act. Further, unlike the Land Acquisition Act, moment the notification under section 3(2) of the National Highways Act, equivalent to section 6 of the Land Act, is made the land vests absolutely in the central government, free from all encumbrances. Therefore, where the land has vested in the central government and the amount determined by the competent authority under section 3Z as compensation has been deposited by the central government in accordance with section 3H1, the competent authority may also direct that possession be taken within so and so. Then kindly come to para 55. It can be seen from the aforesaid provision that the speeding up of acquisition of land needed for national highways has been achieved. The challenge process to an award passed will of necessity take its own time, both under section 3G of this act as well as under the provisions of the Land Acquisition Act. This being the case, it is a little difficult to appreciate as to why the wholesome regime of appeals under the Land Acquisition Act has been replaced by a regime in which an award passed by the arbitrator, who is not consensually appointed but appointed by the central government, can only be challenged not on merits but on the limited grounds contained in section 34. Now, this is precisely what my contention is. Now, therefore, your lordship will see that if there is a fundamental difference on two counts, one, the applicability of the substantive law, and second, the absence of consent, these two elements would have their own impact on the power of the court under 34. Now, as far as statutory arbitration is concerned, therefore, there is a fundamental difference between statutory arbitration and commercial arbitration. Now, in this light, kindly come, my lord, to one more aspect. Hakim notes the judgment of the Constitution Bench in Nagpur Improvement Trust. Kindly turn to para 58 on page 33.
Yes,
It is now well settled that the state can make reasonable classification for the purpose of legislation. It is equally settled that the classification, in order to be reasonable, must satisfy two tests. Differentia must have a rational relation with the object sought to be achieved by the legislation in question. In this connection, it must be borne in mind that the object itself should be lawful. The object itself cannot be against the sections of my discriminatory for otherwise. For instance, if the object is to discriminate against one section of the minorities, discrimination cannot be justified on the ground there are reasonable classifications because it has a rational relation to the object sought to be achieved. What can be reasonable classification for the purpose of determination of compensation if the object of the legislation is to compulsorily acquire the land for a public purpose? It would not be disputed that the different principles of compensation cannot be formulated for lands acquired on the basis of the owner is old or young, healthy or ill, tall or short, or whether the owner has inheritable property or built it up with his own effort, or whether the owner is politician or an advocate. Why is this sort of classification not sustainable? Because the object being to compulsorily acquire for a public purpose, the object is equally achieved whether the land belongs to one type of the owner or another. Can classification be made on the basis of a public purpose for the purpose of compensation for which land is acquired? In other words, can the legislature lay down different principles of compensation for lands acquired, say, for hospital or a school or a government building? Can the legislature say that for a hospital, land will be acquired at 50% of the market value, for a school at 60% of the value, and for government building 70% of the market value? All three objects are public purposes. And as far as the owner is concerned, it does not matter to him whether it is one public purpose or the other. Article 14 confers an individual a right in order to justify classification. There should be something which justifies a different treatment to this individual right. It seems to us that ordinarily classification based on public purpose is not permissible under Article 14 of the for the purpose of determining compensation. The position is different, etc., etc. Now, therefore, the principle that emerges is that whether you acquire under the Land Acquisition Act or whether you acquire under the National Highways Act, I must get the same level of compensation. Now, if this is the principle, will it or will it not have an impact on the content and the amplitude of power under 34?
The difficulty is the challenge is on the restricted ground of 34. It makes no difference.
I'll come to 34.
But if we accept that the grounds of challenge can be increased or decreased depending upon this, whether departmental officer is the arbitrator, as it used to happen before the constitutional bench says independent arbitrators have to be appointed, it will lead to a problem. But we can't expand and decrease the scope of.
So the principle as far as substantive law is concerned is
Let me
same.
put it may be a indirect influence, not a direct influence, as far as 34 is concerned.
The Article 14 has other dimension. Now, this is as far as substantive law is concerned. Now, as far as the forum is concerned, in my respectful submission, Article 14 will have its impact on the content and the amplitude of the power under 34.
What precisely is your argument?
My argument is this, that in case of commercial arbitration, the private law elements are involved. While acquisition of land for a public purpose under the National Highways Act or under any other compulsory law of acquisition, the parameters are different. And if that is so, and if the arbitration is involuntary, the jurisdiction of the court under 34 must be differently viewed. You cannot have, if you have the same standard in all cases, whether commercial arbitration, consensual arbitration, compulsory arbitration, public purpose, etc., then two dissimilar situations, jurisdiction will be same, and that would be violative of 14.
Bilateral arbitration, particularly after court, these provisions have become subject to what the
So
union.
the remedy also must be of the same level.
How can 34 scope be different, Mr. Nabde?
The 34 scope will be different for the simple reason that the parameters
If he's violated the statutory provision, and that is the cause for the patent illegality of fundamental, then in that case, we can expand, we can stretch that illegality. But the power of modification has to be read into 34, or under 34(4) as it
I have
may be.
still not touched 34. I'll come to 34 a bit later. But
We have understood this
my
argument.
proposition
We have,
is this.
we have
Now
understood
take a
this.
case, for example, your lordships have said if the acquisition is under the same notification, then the rate of compensation to two different owners must be same. Otherwise, there is infraction of Article 14. Now suppose in a case arising under the National Highways Act, two different owners are given two different rates of compensation and their properties are acquired under the same notification. Then a restricted view of 34 would warrant that the discriminated owner has to go back and start the process all over again. Now look at the kind of injustice. It will defeat the very objective of expeditious resolution of disputes. I am not saying that in every case the court will have power to modify. But to say, to take an extreme proposition that in no case the court can modify would be too wide a proposition. Too wide a proposition. Now, sir, come to section 34. Let me make my submission on 34. First, this power is conferred on a civil court. If your lordships may have a look at the definition, it says a principal civil court of original jurisdiction which could have taken cognizance of the subject matter of the arbitral dispute. Now, why this power is conferred on a court and not on a person or designator? There is a reason for it. And we proceed on an assumption that when Parliament enacts a law, the Parliament is aware of the existing law. Now, what is the existing law as far as the civil court is concerned? Two propositions. It can take cognizance of matters of a civil nature unless its cognizance is expressly or impliedly barred. That is proposition number one. Proposition number two, that it has inherent power to do justice. Now, in order to curtail these powers, that is, power to take cognizance of matters of a civil nature and power to pass such orders as are necessary to meet the ends of justice, you need specific legislative provision. In the absence of any prohibition or any absence of any restriction on the exercise of this power, the court is free to pass any order that is required to meet the ends of justice. Now, let me show to your lordship in this context what fetters have been placed on the powers of the court. So, first, kindly come, my lord, to section 5. Section 5 of the Arbitration Act. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. In the absence of this, a civil court was competent to take cognizance of a matter of a civil nature. Under the 1940 law, merely because there is an arbitration clause, the court's power to adjudicate upon such a suit was not taken away. In fact, under that law, the court was required to pass an order staying the suit and allow the arbitration to continue. But if that was not done, any arbitration that would continue without the court stay would result in a nullity. So, Section 5, therefore, alters the existing law. It's a fetter which is placed on the court's power. And why those provisions in the 1940 Act? The reason was that the court was competent to take cognizance of the matter, but if there is an arbitration clause, the court is empowered to stay the suit. In other words, the court puts a fetter on its own jurisdiction. Now, this is completely altered by Section 5. And the proposition is that any provision which restricts the power of the civil court must be strictly construed. So, if two views are possible, then the one in favor of the jurisdiction of the court must be preferred. And this is precisely the present situation. Then kindly, sir, Section 8. A judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies, not later than the date of submitting the first statement on the substance of the dispute, then notwithstanding any judgment, decree or order of Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Now, this fetter is couched with rider. It says that if the court prima facie forms a view, then only this power can be exercised. So therefore,
On an application, Mr. Nabde.
on the application,
Suppose somebody doesn't apply at all.
then the suit will proceed. That's what I'm saying. That therefore your lordship will have to see the provisions of the act in that perspective, that whether there is a fetter and whether the court's jurisdiction is completely taken away to pass orders or even on merit, then your lordship will come to section 9(1). A party may before or during arbitral proceedings or at any time after making of the arbitral award, but before it enforced in accordance with section applied to the court. So again here some fetter is put on the court's power under 9(1). Then kindly see 9(3). Once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that the circumstances exist which may not render the remedy provided under section 17 efficacious. So here again a power has been restricted, but in certain circumstances the court can still exercise power under section 9. Then your lordship will come to section 11(6)(a). The Supreme Court, or as the case may be the High Court, while considering any application under subsection 4 or subsection 5 or subsection 6, shall notwithstanding any judgment, decree or order of any court, confine to the examination of the existence of an arbitration agreement. So the jurisdiction is restricted. Then your lordship will come to 37(3). Kindly see 37(3). No second appeal shall lie from an order passed in an appeal under section, but nothing in this section shall affect or take away any right to appeal to the Supreme Court. Then your lordship will come to 42. Notwithstanding anything contained elsewhere in this part or any other law for the time being force, where with respect to an arbitration agreement, any application under this part has been made in a court, that court alone shall have jurisdiction over the arbitral proceedings and all subsequent applications arising out of the agreement and the arbitral proceedings shall be made in the court, in that court and in no other court. So therefore your lordship sees that whenever the legislature wanted to put fetters on the court's powers, it has done so. Now I come to the second proposition. Court has inherent powers. I take it that nobody is disputing that the power under section 34 is a judicial power. In any case, that issue has now been resolved in Patel engineering case, that even power under 11 is held to be judicial. Now, if it is a judicial power, where is it defined in crystal clear terms? If it is not defined in crystal clear terms, then a proposition follows that it's a power which is not limited by any limiting factor, which is to be found outside the provisions of the Act. So if any limiting factor is to be found on the court judicial power under 34, it must be found in the Act itself. If cannot be found in the act itself, then in my respectful submission, that power remains unlimited.
Only if 34(2).
I'm coming to 34(2). Now I draw a distinction between section 34(2) and section 34(2)A on the one hand and 34(1). Now 34(2) and 34(2)A deal with jurisdictional issues. They do not define the powers of the court under 34. They are jurisdictional issues, that when can a court take cognizance of a matter under 34 when the circumstances enumerated in section 34(2) and section 34(2)A are shown to be existing. The power flows out of 34(1). That's my submission. Now kindly see 34(1). Recourse to a court against an arbitral award. Now my emphasis is on the word recourse to a court against an arbitral award. Now that recourse is for what? What is the concept of recourse to a court? This concept necessarily postulates a power, a right to seek justice. No other interpretation is possible. It's a recourse to seek justice. And therefore, if it is a judicial remedy, and if section 34 does not define or does not limit the court's power, then in my respectful submission, the court has power to touch even the merits of the case. So the second aspect now.
Yes, please.
Now, let us take a case where the award is set aside, but the list still survives. Now take, for example, the arbitrator wrongly rejects the claim, contrary to all settled principles, or does not allow substantial evidence to take part of the record. Complete denial of natural justice. Award is required to be set aside. That does not put an end to the list. If the list survives, then there are four possibilities. The court says nothing. Because if we go by the rule of strict interpretation, after setting aside the award, the statute does not make us wise as to what is to be done.
No, 43 does provide for that. 43 does provide for that. Section 43 does provide for it.
So
Says
I'll
both
come to
options.
that.
Gives you two options, either to go
That
to the
I'll
court.
come to 30. I'll come to that provision, subsection 4 of section 43 a little later. But 34 does not. 34 does not itself say. There cannot be vacuum. The list remains, there can't be vacuum. Now kindly have a look at, in this context, 43(4).
Yes.
Too literal an interpretation of 43(4) will play an havoc. Where the court orders that an arbitral award be set aside, the period between the commencement of the arbitration and the date of the order of the court shall be excluded in computing the time prescribed by the Limitation Act for commencement of proceedings. Mark that word, proceedings, including arbitration with respect to the dispute so submitted. Now, this provision contemplates two things: arbitration proceedings and some proceeding dehors arbitration. Will it be a suit? what is the nature of that proceeding, which is other than arbitration proceeding. So my respectful submission is that 34 does not tell us. I'm not on the content and the amplitude of the power. I am on whether it is original. The court jurisdiction under 34, is it original? Is it appellate? Or is it revisional? Whichever way that your lordships are inclined to take a view, the court still has the power to pass appropriate orders. Otherwise, there would be a vacuum. The court simply sets aside the award and leave the parties to decide for themselves what is to be done. This creates a situation of uncertainty.
Why, Mr. Navade? Suppose it is set aside on the ground that it contemplates matters beyond the scope of arbitration.
Then matter ain't no. Therefore, I said, where the list survives.
This survives and that will be suit because it's not arbitrable and period is excluded.
If it is not arbitrable, then the party concerned would take appropriate either a suit. Take, for example, testamentary matter. Not arbitrable. Then the party concerned will go and file a suit or testamentary petition or whatever is the remedy. But the point is that the list survives. It may survive not for the purpose of arbitration, but it does survive.
Now, there are two things. Why they say list survives. Sometimes when you decide the matter in the section 34, the list may not survive. Suppose it says, comes to the conclusion that the first arbitration, that the termination of the contract is valid. And that is upheld by the court. That's been upheld by the court. But where the court interfered was, say, a small aspect with the enhancement of prices of the goods or the services. That the court says in terms of the arbitration clause, that could not have been awarded. The list doesn't survive. Where the list survives, you'll be entitled. Will the Act tell you is your, why will the Act tell you? Will not guide you.